video discussion on Karnataka Scheduled Caste and Scheduled Tribes Prohibition of Transfer of Certain Lands Act 1978. Friends, this is one of the small legislation consisting of just 12 sections in head, just to see or put a restriction in respect of any transfers that is going to be made of the property or agricultural property, more particularly belonging to that of the scheduled caste and scheduled tribes, which says like this, that is, when a property is granted to the person, that is by way of grant belonging to the people of scheduled caste and scheduled tribes, which we consider them to be as a weaker section and poor people, not everyone I'm speaking, but generally, when they consider as a poor people, and when the property is being given for them for their livelihood, if that property is going to be transferred by them for the maybe for the sudden need or maybe in the guise of undue influence on their part, the person may again be left out without anything for their livelihood. In that sense, or with that objective, we see that the act was being brought in. And from the point of your examination, if you look, my friends, I expect two questions from this part. Though it is very small enactment, one is they can ask you about the scope and objectives of this enactment, or they may also ask you saying that the prohibition of transfer of certain lands has provided, that is transfer of certain land or granted land under the Karnataka SC and ST PTCL Act 1978. They may ask you with these two questions. So we shall understand what exactly is this. See, they say that is, when I say prohibition of transfer of certain lands, the certain word certain speaks or notes to, signifies to only certain kind of land. It is not that to every land of what SCSTs are holding. It is not that. Maybe if the land, if I have purchased with, being a person of ST community, if I have purchased the land of my own, that is out of my earning, and if I am to hold the land and if I want to sell the land, there is no restriction on it. It is not applicable. This act only confines or applies to the case where if the land is acquired by a person, when we say certain lands which cannot be transferred, then the word certain here speaks with grant. Where the land is granted to the person, where the land is being provided by the state government, or as a land is being provided by the state as a grant to the person for his personal enjoyment. If that land is going to be transferred upon with, then the person may again have to live without any such property in him. That may hamper his livelihood. With that notion or with that objective, we see that the PTCL Act was being brought into force. And we say, in fact, the Act was introduced in the year 1978. And when the Act was introduced, this Act was given a retrospective effect. I like to say you there are very few laws which would be given a retrospective effect, my friends. Very few laws. Usually, it's very difficult to go with retrospective effect. But it is one such piece of enactment which has given a retrospective effect. And that is the reason why we call this law, or it is considered to be as an ex post facto law. Ex post facto law. For the reason that is, the law is not only applicable in the prospective nature, but also applicable to that of retrospective nature, which said like this. That is, where if any agreement is entered between the parties, where any sale is being made between the parties, that is, a person who is happening to hold a land, if that land is being transferred, before the commencement of this act, still such transfer what is being made becomes null and void. That is what the effect of ex post facto law, and that is what it is considered with. And we also look down certain difficulties that has come in this regard. Today, friends, when you go with having looking at as why this law was brought in, friends, after having provided a grant, that is land grant was being given to them, about in Karnataka, I am just speaking, just in Karnataka, I am speaking with this. There are about more than 10,000 hard number of cases that is being filed before in respect of this. And still it has been pending, I can see. It is still pending before the Deputy Commissioner. But if you look at with all these things, why has this cases been brought in? What for? Maybe under the guise of undue influence, they would have taken the property. Or exploiting the poverty of that people, they would have taken upon the property. Or in the guise of any other manner, they would be taken away with the property. So in that sense, in that scenario, the act was brought in, we see. That was the aim, or that was the object with which it was brought in. And we also said, we have understood this. See, the land, what has been created by the nature, is definitely for the welfare of all the individuals. And more particularly, when the land reforms was brought into force, or land acquisition for that matter, any of these things if you look in, it is a welfare piece of legislation, I can say. So, the land what is been created has for the social welfare, or the land what is been given, granted to the person as a social welfare, that aiming to protect the interest or providing a protection of these people, that is for the poor members, especially to the people or category of SC and ST castes as such. If you take away the land from them, taking away the source of their livelihood, this becomes important for them to lead their life. And the legislation would not serve the object of its welfareness if you are not putting a restriction on that. In this sense, or at this backdrop, I can say, this legislation was brought into effect. That is, to provide a protection to those of the persons for whom the grant of land is being made, by exploiting their poverty, by exploiting their innocence, by exploiting the necessity. If you have made use of that, then that should not be benefiting you. You should not benefit from that of it. That was the idea in which it was brought, and the sole reason is to protect the interest of the people for SC and ST for whom the grant of land is being made. And unfortunate is also on this part is that, my friends, due to the lack of clarity and understanding between the judiciary and administrative in this regard, there exists still a large number of cases before the DC. Still it exists before the large number of cases. So when we go with the act, in fact the act provides saying that, or aims at not transferring certain lands which is being granted to them by the government. I'll go repeat this again. The act prohibits of transfer of certain lands. I'll again take undercoat with bold voice, saying that certain lands which is being granted to them by the government, more particularly to the person belonging to the category of SC, ST, that is, where the land is granted to such person for the use of agricultural purpose, or where the land is being given to the person who of SC, ST, or more particularly agricultural laborers, then the same cannot be purchased by any other person. That is the limitation what it has been putting with. Such land cannot be purchased by a person who is holding the property. And any purchase of such property, in spite of this, if a person purchases the property, then such person will, after its acquisition, gets no marketable title over the property. And such property will eventually be acquired back by the state government, and the state government can again return back this property to the original owner. And even where a person, while resuming back the property, taking away the property, forfeiting the property of which the person has taken wealth, it may not pay him any compensation for the property which he has been purchased with. So the whole situation which we see or which comes here is that when a grantee goes and sells the land of which it has been supplied to him by the government, then such grantee, when he sells the land, if a person is being restricted or is being prohibited from accepting such land, he cannot, even where an offer of a person, that is a person belonging to SC, ST, where the grant is being given to him, if he himself makes an effort, and if he says that he offers you for taking the property or enters into an agreement to sell the property, it becomes ineffective. Nor you also, you cannot make your offer for taking of such property because it is ineffective. And the registration, even though that you might have carried a registration, you might have purchased, you might have paid a very good marketable rate, or I can say you that a fishy rate can be given on that of the property and it could be registered, but still, my friends, we shall see that the same what has been taken by you can be rejected. The same deed what has been effected by you before the register of authorities can also be rejected, and the sale deed can be considered to be as null and void. So in a wholesome, I can say this, it is an act which imposes a limitation that no land cannot be sold without the permission of the government. Friends, then it was a situation, that is before the act came into force, I am speaking with. When the grant was being given to any category of person, the state government was an appropriate authority to fix the conditions on it. And the usual conditions was something like this, that when the land has been granted, it had a cap in itself that the land should not be sold for 15 years, nor any interest shall be created in respect of the land for the period of 15 years. But it so happened like, even with this condition so imposed, the people, because of the need of their financial resources, as a need of financial resources or for the betterment of their economy, what they did is that they started selling out the property immediately after the grant they get in. So the original grantee used to lose the property, and that's how the cap was brought in. The cap was brought in saying that no, you cannot purchase the property. And it has now, this act has been made so severe, saying this, that where an original grantee, if he has acquired the property and later on if it is been sold by him, maybe the other person might have purchased the property with a fishy rate, but still, my friends, he gets no good title over the property. Nor the heirs of this person, after having sold, maybe after 10 years, 50 years, 20 years, or so on and so forth, whatever that is, it could have changed number of hands in that regard. It could have changed 10, 15 hands in that regard. If after the sale is being made, the original grantee heirs who are in existence can come and challenge, even if it is 100 years later, my friends, they can come and challenge that the registered sale deed should be considered as null and void. And the limitation act also does not apply to this. It does not apply. That is, the law of prescription or the limitation act would not come in putting a restriction on this, the claim of this person when he is making. So the current owner in such case, my friends, when after acquiring the property from that of the person, from the property to whom it belongs to SC and ST, shall return back the land, including the building of what it is there. That is, he might have developed the land, he might have had certain infrastructures in it, whatever that he might have done, but he has to give up the property, he has to leave up the property of the reason of this, and is not even entitled to obtain a compensation. I was saying you that. And not even the tax paid on it. Even where if you have paid a tax on it, even that is not be entitled. The revenue what you have been paid on it is not being entitled by you to claim upon with. That's the effect of this. Whatever the changes it has been taken place, whether it is 5, 10, any number of hands, but unfortunately, because of this act, if you are a purchaser and the last person who has to take the who has to take the burden of loss, or who has to bear the loss of what has been affected. So this is the background on which we shall see that, my friends, the act was being brought in. That is, it says any alienation cannot be made forever. And before this act, as I was then speaking to you, there was a clog on this, C-L-O-G. Clog is nothing but a condition. A clog was there, that is, a person after having granting the land, he should not sell it for 5 years, then it was extended to 10 years and it was extended to 15 years or so. Now, within that time, they were, of course, after the time tenure, they used to sell out the property, and this has become so rampant. And many cases it so happened that when a person acquires the property, obtains a grant of the property, suppose say for 10 years if you take, before 10 years, the person, that is a wealthy man, what used to do is that he used to pay certain money to them, maybe a property worth of, suppose say 5 lakhs of rupees, he used to pay 50,000 and used to enter into a sale agreement. And after the term tenure, they used to take away the property from them, because these people were very poor and they were the giants in that area. They used to take away the property, whether forcefully or whatever it is. So this was happening. So to overcome with this, my friends, there was a cap was brought in, the clog was being imposed. So after the act was being brought into force, irrespective of any condition, see, then you were given with this. But once when the act was being brought into force, irrespective of these conditions, whether there is a clog of 5 years, 10 years, 15 years, or whatever it is, whatever that could be imposed on you, in not having, that is a non-alienation clause could be there for 5, 10 or 15, whatever it is, but still no alienation can be made thereafter. It was once when the grant has been given, it is perpetual in nature, in respect of that person or in respect of the family of their members. That is family members. Except of this, no alienation can be made. It also said that, that is, when it is required to be alienated, you have to go before the officer, obtain the permission from the officer, that is, you have to take the permission, and only on such permission so obtain, if the consent officer, that is usually DC, the DC, if it is satisfied that the alienation is necessarily required with, then he may allow, very rarely we come across where the property is going to be allowed to be transferred with. He may be allowed for having been transferred. So in this way, there is a restriction, and if any violation has to the condition of this, my friends, by any of the person it could be, if there is any violation of this condition, they can straight away go file a complaint before the Tahsildar regarding with the violation that has been taken place, and the report of the same shall be made by the Tahsildar and sent to the DC. The DC shall even decide on this. So this is the background of which the act was being brought in. And I said that, I was mentioning you that this enactment contains 12 sections, only 12 sections in it. First, second is something. First is the enforcement clause, second is the definition clause, the third one is giving that is in terms of constitution of the article 31 C, giving the right or giving the enforceability in terms of article 31 C, and so on and so forth we go with. Now, what does the proviso speaks with? Same thing what I have discussed to you, to be speaking. Now, under section 4 of the act, it prohibits the transfer of certain granted lands. It says that withstanding to any such agreement or contract or creation of any instrument, it says no transfer shall be made in respect of the granted land, or no transfer shall be made in contravention with the terms of the grant in which it is being made. That's what I was saying. That is, if there is a non-alienation clause, whatever it is, no alienation can be made irrespective of the time that is being given to it, with a retrospective effect. And it says any transfers that is being made would become a null and void. The transfers would not become effective. The purchaser would get no good title. No right of title or interest should be transferred by such transfer, and even where it is transferred, it is deemed to have that the property is not transferred from transferor to the transferee. So this is the restriction imposed against the person with that of the land what is being granted. And when you read section 5, it speaks with the resumption and restitution of granted land. In spite of this restriction, suppose if you sell the property, if you alienate the property, or if you create any interest in the property, what would happen? There it says that, of course, we have also read this under the same 15, that the resumption of land under section 15 of the Karnataka Land Reforms Act, where we see that is in case of the land reforms is concerned, resumption is with respect to the sailor and the seaman. That is, he can get back the property. But here it is in case of SC and ST. It says that is on an application by any person or any interestee gives an information in writing, or sometimes even it is suo motu. Suo motu, they've come to know that the land has been transferred from one to the another. That is, the land belonging to the grantee land belonging to that of SST has been transferred upon with. Then they can cause an inquiry in this regard as they find deemed necessary on it. They can cause an inquiry. And where in this regard, if the AC is satisfied that regarding to the land what is being transferred, his granted land, then he can treat that the transfer to be as null and void. Then in such case, he may also order such person to evict the property from out of the possession of property, evict such person, or also he may order for restoring the land of such property, agricultural land, to that of the persons or to the legal heirs. Where it is not possible to restore the property to that of the person who has sold the property to them. I was saying you, when I say selling the property, when I say the property is being sold, maybe first SC or ST man might have sold you the property. It might have transferred, he might have transferred to Mr. N, N to M, M to O, O to P, P to Q. There could be a number of persons here. But when Q is required to restore back the property, that restoration does not mean to say that he should be giving back to the property to P. No. The restoration should be in favor of this person who have let you the property or alienated the property for you. Where if it is not possible to be done, then such property shall immediately vest with the state government and the property shall be free from all those encumbrances. So this is the restriction what is being made. You have to give back the land of what you have taken with. And under provision section, under section 5 class 2, it provides that subject to this deputy commissioner, that is subject to that of the provision of section 5A, appeal to DC we speak upon with, can pass an order in this regard, and that order what is being passed shall be final and it cannot be questioned in any court of law. That is, any disputes with respect to this cannot be questioned and it cannot be. And in this regard, my friends, where an appeal has been preferred before, no injunction shall also be granted in this regard when it is been transferred with. That is, where a question of subject to the land which belonging to SCST is there, then no question of even granting an injunction or stay in that respect would be allowed with. Even the Prohibition of Transfer of Certain Lands Amendment Act 1984, that is, which has brought an amendment to this, it says, an order of AC to take the possession of the property or restoring the property, and where an appeal is being preferred on this, that is, if an order is being made by AC and if an appeal is being preferred on this, then on the DC who is admitting the appeal on the appeal which has been preferred against this shall be determining this within 3 months of time. The DC can even go, that is, within 3 months he has to pass an order, that is, orders has to be communicated to the person, that is all this, that is there. And where the DC can even admit the matter of this case, even where it is time barred. It is no question of timing barring. You can, even if there is a delay in filing, it could be made, provided wherein, and an appeal I am speaking, provided the DC can take, that is, AC can make a reference and pass it to the DC for restoration, and the DC can take up this matter of appeal in case where the appeal can be admitted, provided wherein, my friends, there is no writ petition filed in this regard, or where there is an order passed by any such competent court in the writ petition before when the suit is been pending before the court. Subject to this restriction, the DC has a power to take an appeal even where it is a time barred one. So this is one restriction which has been imposed. And under section 6 we see there is also a prohibition of registration of transfer of this kind of land. It says subject to the provisions that is as specified under the Registration Act 1908 on the commencement of this act. I am speaking not before what has happened before this enactment has come, but on the commencement of this act. It says the registrar authority also shall not accept any such registration of any document relating to the transfer and creation, because it is usually, friends, when it comes to the registration authority will not look into whether the land is competent to be transferred or not. It never looks into. Normally they don't look into. But when it comes to the question of this, my friends, it is very much necessary. The registrar has been given now a right with a bounded duty. I don't say right, bounded duty. It is mandate now. He cannot get into the registration of this. That is, he cannot register the land which has been granted by the government. So in this regard, every such officer would give a copy of such registration, that is list of granted land, should be furnished with the registrar, that is registering officer, except as the transfer is in accordance with the act. He cannot accept that registration. That is, unless with the consent DC, he cannot accept. However, a small exemption is being given to this under section 7, where it says, where the transfer of granted land is being made in favor of the government, that is state government or central government, or to that of any local authority or the bank, either before the commencement of this act, then this enactment is not applicable. So except this, even if it is being made to a private person, excluding these persons who falls under section 7, the land becomes liable. That is, the person becomes liable to redeem back, and resumption shall take place in respect of the land. And what section 8 speaks is that it is a penalty clause which says, whoever who acquires the land as against to that of the provisions of this act after the enforcement of this act, then such person shall be punishable with imprisonment, which may extend to the period of 6 months, or with fine of whatever it is. That is, fine of 2,000 rupees, or with imprisonment of 6 months, or it could be any one or both. It could be any of this. So the penalty can be imposed. However, section 9 is an exception to section 8. That is, when an imprisonment cannot be ordered or when penalty can be not be imposed, is that it is a protection clause. I can say protection is being given to a person who have acted in good faith. It says, no suit shall lie or no complaint will lie against, but it is not validating the transfer what you are making. It says that as far as only to the penalty is concerned, only to that of the imprisonment is concerned, it says that no suit or no prosecution or other legal proceedings shall lie against the person or such an officer for any such reason that where if a person have acted it in good faith or done it in good faith, that is in pursuance of the act, following the rules of the act. Maybe he might have overcome with the rules or anything that, but still he should be excused in that regard. So subject to this, my friends, we shall see that he should be even penalized and penalty can be imposed. And in this regard, it is section 10 gives you the power to make rules. That is, the state government shall, by its notification, it has a power to make rules and to carry out those rules on the purpose of this act is concerned. It can make any such rules in this regard so that the authority shall carry upon with, and where the rules are made therein, then it should be passed before both the houses of the legislatures, and where the sessions agrees with the same, and if they want to have any modification that can be made, but the rules has to be applied with. So these are the provisions. Of course, section 11 speaks with the act overriding with other laws. In fact, I can say you like this, my friends. This is the beauty. See, normally it so happens like this, my friends. When a special law is being enacted, no law can overtake with this. Suppose if any of the law, that is, suppose say take the example the Contract Act itself. In a Contract Act, what is that? We say that when a person enters into a contract to perform certain thing, then you can go for an enforcement of that contract. for the performance of that contract. But by virtue of this provision itself, we see that though contract act provides you a right here, but by virtue of this contract becomes unenforceable in nature. That's what it says, that is, the section 11 says that this act would override with all other laws are concerned. It says the provisions that is being provided under this act provide, saying that is any custom or usage or practice or contract that is being made, or decree or order of the court is being made by the tribunal with respect to all of this, if any such thing is being made contrary, it would override and says that this is not applicable. So this is the power or the strength of this act is concerned. And it is also, my friends, as I was then saying you with section 12 will also, it is speaks with to remove the difficulties. That is, if any difficulty arises which has been in enforcing upon or giving effect to this of the provisions of the act, then the appropriate government shall have a power to pass any such general orders, maybe in respect of execution or in respect of any other things for that matter, to remove those difficulties. The government has a power to pass any such general orders, and the orders what is being passed shall be notified in the official gazette, and from that, my friends, it becomes into effective, provided it says, of course, provided it says that no such order shall be passed after the expiry of 2 years of time from the commencement of this act. So I see that, I believe the provision 12 is also redundant in this regard, because 2 years has elapsed on that, and it may not be effective for us in going this. So as a person, when I am going to purchase the property, it is my bounded duty to see that the land what I am purchasing is not a grantee land. More particularly, whether that land belongs to that of the SC and ST, because it is the cap is only in respect to that of SC and ST land. But if the land is being given to another person by way of grant, that's what we have discussed under the Land Reforms Act, then that is 77, it could 77, we shall see that those land can be purchased subject to the restriction of non-alienation clause. Subject to that, you can purchase with the other persons are concerned. But when it comes to SC/ST, you cannot have a purchase of the land, because there is a complete tag, that is lock on the transfer of that property. So in order to assure that, my friends, what you are required to do is that when you are going to purchase the property, you are required to obtain a clearance from the appropriate authority, that is, whether it would fall under the PTCL Act. So an endorsement certificate shall be issued by the authority, that is usually the Tahsildar or district collector of the relevant area shall provide this document. So when you get a certification of an endorsement, that is endorsement certificate, as that the land is not a grantee land or grant land and does not belong to any SC and ST, then you have a way to proceed on this property, as it is not an SC/ST land and it is not a grant land. So subject to this, my friends, you can see that the land can be made. So what the entire act speaks is this. In a bird's way, I can say is that it is that enactment which imposes a restriction of having purchasing the land or even alienating the land, of which the land is being given to the person by way of grant. Where the land is being given by way of grant, such land cannot be alienated, such land cannot be taken upon with. So there is a restriction on this. Subject to this restriction, you have to go purchase the land. So no land can be transferred where the land is belonging to the property of SC and ST, and only the heirs of the person or the successors by way of devolution, we see that the person, that is, who inherits the property, can only have a right of enjoyment over the property. They can divide, subdivide, they do all these things, but only thing is, it is only among this person. So this is the restriction what we see in respect of the